is Mid-Atlantic Women in Agriculture's Wednesday webinar, Legal Considerations with Energy Leases. Our presenters today are Ashley Ellixson and Paul Goeringer. Ashley and Paul have provided their email address at the end of the presentation for all questions. All archived presentations, along with all upcoming presentations, can be found at our website. And a special thank you to our sponsors, Mid-Atlantic Farm Credit, Delaware Department of Agriculture, and Maryland Department of Agriculture. Thank you for listening.
You're welcome. So we will go ahead and get started and talk a little bit about legal considerations with energy leases. And I had better mute my phone so nobody hears my phone go off constantly. So before we get started, we all need to remember that this is not legal advice. I've changed up the normal disclaimer we usually give so everyone can kind of get the idea that this is not legal advice for what we're going to talk about. We're going to talk about a lot of general conversations, and as Victoria is pointing out, if you have questions, please type them in the chat pod as we go along. So to give a little bit of a basic overview, and Ashley, when I'm supposed to stop talking, please just jump in and tell me to be quiet. To give a little bit of background, these things, energy leases are basically just legal agreements that are going to impact your property in some way. And the idea is you need to at least have an understanding of what those legal impacts are going to be as to how they're going to impact you long term. These things, for the most part, especially with solar or wind, are going to be on the property for 20 to 30 years or potentially longer, depending on the terms of the lease. So the idea is to early on try to figure out how this is going to impact future uses of the land and how the clauses are going to play out over the course of this time. So where are we going to go with this today in the hour? We're going to talk a little bit about common terms. What does a typical agreement look like? Ashley's going to talk about those two and the length of the agreement. Who needs to be involved in this process? Because it is a long-term agreement, it's probably not just going to be you by yourself or you and a spouse. It's going to be you and whoever other heirs on the farm are going to be down the road. Being a part of this process is potentially going to them as well. And then look at some common clauses. Somebody's mic is on and we are getting feedback. And common clauses, and then federal and state laws that could potentially impact this process as we go along. And now I'll hand it over to Ashley and let her introduce herself so she can talk about the common terms.
All right. Hello, everyone. I hope everyone can hear me clearly. I know we had some issues with mics earlier. And again, my name is Ashley Ellixson. I'm also an extension legal specialist with Paul, and it looks like everyone can hear me clearly, so that's great. And I'm going to go ahead and go over some common terms. What's basically needed from the landowner is what I'm going to go over now. And just to preface this, this is not an all-encompassing presentation. That these agreements can be very, very detailed, and every area is going to have something a little bit different. Every company is going to have something a little bit different. So this is definitely a general overview. I just want everyone to keep that in mind as we move forward, and if you have questions throughout, please feel free to ask. All right, so energy lease terms. So the short version is basically the ability, the landowner is going to have to grant the company the ability to access the wind, convert it to electricity, and then send the electricity off-site. This is usually accomplished via a series of easements and then an overlying lease. So I'm going to go over some of those easements first. So the company is going to be granted the easement to access the land. So what does that entail? It allows the developer to travel across the property to reach the turbine or the solar areas, and that is considered an easement that the landowner will be granting the company. Additionally, there's also the construction easement, and this is often tied to the access easement because it gives the company the ability to actually construct the turbines on the land or the solar panels, and then also the support systems that go along with those systems. And then also transmission. So this gives access for transmission lines underground and overhead between turbines, the substation, transmission lines, and again, the other support systems that go along with either the turbines or solar panels. Also, the landowner may have to agree not to engage in any activity that interferes with wind speed or direction. So this is something else that can be outlined in an energy lease. So the same can be said for not obstruction of sunlight for solar. So that might mean, for example, that the landowner may not be able to build another barn or another building that may obstruct sunlight from reaching a solar panel. So those are things to look for in a lease as well and to keep in mind as a landowner. Overhang. The landowner may have to agree to allow turbine blades to overhang your property if the turbines are on adjoining property. So this is going to bring into play the neighbors. So again, this is going to differ within different zoning requirements. It may be that the turbine blades do actually overhang the neighboring property, and they'll have to get the permission of that neighbor to do that. But again, depending on the zoning and the area you're in, this may not be an issue. But it is, again, something to think about. And then in most cases, solar panels will cease any other use of the particular land it is built on. So that kind of, because of the solar panels, they're closer to the ground, you may not be able to do anything else underneath those solar panels, which I think is fairly obvious, but again, something to consider if you're working with an energy company. Also, something else to look at is noise. Allows for noise from operations up to a certain level, often within a specific radius. So this is going to be, again, mostly just for the wind turbines. They do elicit some sort of sound. So knowing that you yourself will have to agree to that, and then probably neighbors, depending on how close they are. The company is probably going to have to talk to them as well. And again, this is not typically the case for solar because they don't generally generate any sound. And I just want to point out a lot of these slides are courtesy of Dr. Shannon Farrell of Oklahoma State. I didn't say that at the beginning, but I do need to give him credit. So length of the agreement. How long do these leases usually run? So industry average is 20 to 50 years, and this goes hand in hand with the useful life of the wind turbines or the solar panels. So useful life of many wind turbines is said to be 20 years, so you want the lease to run at least as long as the useful life of the turbines. And that just makes sense, generally speaking, as far as how much energy is going to be generated, and if you're going to put something like this on the property, the company and the landowner are obviously going to want to get the biggest benefit out of that construction. The majority of manufacturers offer the 25-year standard solar panel warranty. So what that basically means is that the power output of the solar panel is not going to be less than 80% of the total power it's able to generate after 25 years. So typically those leases are going to be around the 25-year mark. So just something to keep in mind, again, when you're looking at these leases with energy companies as to why they run that length of time. Oh, sorry, it looks like my transitions were delayed. I apologize. All right. So something to look at when it comes to the length of leases, you're going to want to look out for automatic extensions contained in the lease. And these can be hidden, and they're not always easy to spot on your own. And this is a good reason why Paul and I always drill home whenever you're looking at a contract in this way. You're definitely probably going to want to have a legal expert look at this for you to make sure that there's nothing that you're going to agree to that you don't necessarily want to agree to, or that maybe you're not able to agree to long term. So an example, early wind lease agreements in Oklahoma contained automatic extensions and options that would have extended an agreement for up to 150 years. And that sounds really crazy. As someone noted, if the agreement had been signed for that sort of lease around the start of the Civil War in 1860, the lease would have finally expired in 2010. So that seems, I think, to most of us pretty unreasonable, especially if most people aren't living to 150 years. So at some point, other players or owners of the land or people that have interest in the land are going to be affected. So just something to, again, look at and make sure to be aware of. Those long extended agreements are pretty much unheard of this day and age, but again, could still be out there somewhere. Landowners will want to be comfortable with the amount of time that the lease will run. That's just what we talked about. And again, you could be tying up the land as the landowner for not only your lifetime, but maybe your children's or grandchildren. So that's when you're going to want to think about, who all do I need to talk to when it comes to tying up the land of the lease? Are you all comfortable with turbine solar panels being on the property? And who is going to be affected by that? And do they restrict what comes on the land with your children's or heirs' goals in the long term? So maybe it doesn't affect them today, it might affect them 50 years from now, but talking to them today is going to be important when signing these leases. And you're going to update your estate plan to include this lease to prevent surprises. So maybe your son or daughter may not be living on the land currently, or maybe they're 5 or 2 years old at this point, and they're going to want to know about this in the future, even if you think that, well, it's obvious they should know. That's when you want to go back to your estate plan, whatever you might have in place, and make sure that the lease is included in that. And then again, just make sure you communicate with your heirs. Communication is going to be very important here. You don't want anyone to be surprised if something were to happen and you were no longer in possession of the land. You want to make sure everyone's aware of what was going on with the land at the time that the lease was signed, and what the goals of the company were and what your goals were as well. So this could also affect the sale of the land. The lease may include whether or not the project terminates with the sale of the land or transfers to a new owner with the sale of the land. It's typically the latter, because most companies aren't going to want to put all their work, effort, and money into either a solar farm or a series of wind turbines, and then maybe you sell the land a year later and they have to go in and take it all out. So typically it's going to be that it's going to transfer with the sale of the land to the new owner. And how do you own your property? I'm going to go ahead and send it back to Paul to walk you through this step here.
Okay. Sorry, I had to cough. So why are we talking about how do you own your property? Well, the biggest reason why is it's going to entail who all has to be involved in this process and actually what you can give away and lease out. So if you own it in fee simple, it means you're the only owner of the property. You own it by yourself. You don't have to make decisions with anybody else. You can pretty much lease this stuff however you want to. With life estates, you may not be able to own it. So a life estate is typically, the idea is for as long as you live or as long as X lives, and once either you pass away or X passes away, depending on whose life it's tied to, your interest in the property goes away. So whoever gets that property after your interest may also have to be involved in the process, because they're going to be inheriting or taking over the property with this lease. Tenancy in common means you have one or two or more people, and I just realized that my numbering list actually is just all numbered ones, and I don't know how that happened. It should have had 5. That's probably on my end. It's a screw up. But tenancy in common is you have 2 people or more who own the property together in some way, and they all share the idea of how are we going to make decisions in this property. So it may be you with a brother or sister or another family member who own this property this way. Everyone's going to have to agree at this point as to whether or not this lease goes on the property. And when we talk about royalties on it, royalties or land rental are going to have to be split among the partners in the property or the co-tenants. A joint tenancy with a right of survivorship would be, it's sort of like a tenancy in common, but the idea is you own the property with a right of survivor. So as each other owner passes away, the remaining owners take over their interest, and once the last person is left standing, they have it as fee simple. that's also going to require everyone to be on the same page and agree to enter into the solar lease. And then finally, we have tenancy by the entirety. So for all the Maryland people out there, I'm not sure how many people are in Delaware, Virginia, or other places. For everyone in Maryland, this is an issue. If you are married, almost all property you accumulate during your marriage is presumed to be tenancy by the entirety unless the deed says something else on it. It's similar to joint tenancy, but it's only for a married couple. So again, you would have to get both individuals to sign off on the solar lease before it could be entered into. So you and your spouse would have to sign off on the solar lease before you could actually enter into it. So as I point out, why is this important? It tells us who's going to be involved in the transaction. If you have a life estate, we're going to have to bring more people into the discussion, and it's not just going to be you involved in this discussion. It's going to be you and whoever the person that gets the property after the life event, whatever it may be. So we need to know who that is. The other issue is going to be, is it air property? And there's some air property on the Eastern Shore where we potentially have not had anyone do an estate plan in years, and the property has continually been divided up as co-tenancies to where you may, if you're an air property, own 1/10 of an acre or to that equivalent. So it may be we have to get a large group of people involved in this process to sign off on it. And a little bit on easements and encumbrances. The other big deal, especially looking at solar and wind leases in Maryland, is do you have an existing conservation easement on the property? We have a lot of people who have put conservation easements on property, and I will try to look over and answer the question that's being typed out in just a minute. And then we have, how is that conservation easement going to impact it? It's potentially going to impact the development in a lot of ways to where the development is not going to be allowed. Recently, over the summer, the Maryland Ag Land Preservation Foundation has issued rules for how they will handle commercial solar development on preserved farmland. You have to go through an application process, get it approved. It has to be less than 5% of the preserved farmland or less than 5 acres, whichever is less. But you're going to have to go through a written process. You're going to have to get approval. And when we talk about rents, any of the rents that accumulate on this property from solar development or wind development are going to have to be paid over to MALF based on how much land comes out of or is still in preserve. So if we preserve 5 acres, we're going to have to pay the rent on 5 acres to MALF that we get. So there is going to be some ability for the government to come back in and get some of that money, especially if it's preserved through MALF. If it's preserved through other land trusts, land preservation programs, you're going to have to check with those individual land preservation programs to see how they're going to handle it. Some of them are not going to allow you to do it. Others may be willing to work with you, so it's something you need to be aware of. What are some other encumbrances that could exist out there? It could be encountered in other ways. You may have regular easements on it, not a conservation easement, but maybe a high line easement, a gas line easement, some sort of easement out there that we may have to get sign off on that you can actually put the solar project out there as the landowner. And mortgages. And I will answer Lauren's question in just 1 second after this slide. You're going to have to see if any of this restricts your rights to sort of sign a lease. Mortgages and easements may not, but you still may want to check with your lender if you're dealing with a mortgage. And with easements, you may just want to make sure that it's not going to impact any existing utility easement on the property. So the question is, do leasees have option to approve the contract buyer before buyer takes possession? So I'm assuming we're talking about in a farmland leasing situation. I want to make sure I'm going to talk about this in the right leasee situation, because it can impact. Okay, now I understand. So it could potentially be written into the contract that they have to approve the buyer. I was reading one solar lease this week that basically forbid any sale of the property without their prior approval over the life of the lease. It was also probably one of the worst written leases I had ever seen, because in one line it said the landowner could continue to operate it however they had traditionally operated it for agriculture. The property was owned by an individual who leased it out to another farmer. And then in the next line said you could no longer lease it out. So some of them are poorly worded on what exact rights the solar company has, and they will take up as much rights as they can. So it's up to the parties to sort of negotiate some of that out. We can talk about Greta's question at the very end. I think we cover part of that, but we can fill in the blanks at the very end if we don't exactly touch upon it. So some other landowner issues are, so the landowner has a mortgage out there. The energy company may require the lender holding the mortgage to sign off, and that the lease takes priority over the mortgage. Why would we want to do this? Well, the person putting the project in does not want to lose the land from underneath them. They want to make sure that they have some sort of priority in the piece of property they're leasing. And many lenders may go ahead and sign this, some may not. It just depends on the lender. I have a tendency to get ahead of myself as I present. Ashley's going to take back over from here and talk about some common clauses.
All right, thanks, Paul. I am back, everyone. All right, so some common clauses I'm going to briefly go over that you should be aware of as a landowner. Confidentiality clause, duration clause, rent clause, royalty clause, assignment clause, liability clauses, tax clauses, future use of the land clause, insurance clause, termination clause, remediation clause. So all of those I'm going to briefly go over individually. The confidentiality clause. So some contracts include a confidentiality clause to prevent parties being offered a contract from discussing the terms of that contract with other parties being offered a contract. So maybe it's your neighbors that the energy company is also talking to as well. And these could be narrow or they could be broad. They could be either limited, for example, to data collected during the option period of the lease, or it can include maybe the entire agreement. So all periods and all information. So just be aware if there is that sort of clause in the lease that you know what it covers and you're abiding by either what they've asked for, or again, if you're working with a legal representative, that they can negotiate that for you. Duration clause. So like I talked about previously, these leases can go 20 to 50 years. So the leases are typically split into two periods of time. One component is a contract to lease the wind solar development rights for some fixed length of time. I don't know why it says me time, so I apologize for that typo. So that usually lasts 3 to 5 years, and it excludes other companies from developing on the land. And it typically covers the time that the company is going to do the research on the land, make sure that it knows where it's either going to build solar panels, where the turbines are going to go. It's going to do, it's basically the research. The second component is the contract for the actual tower and related development, such as access roads, or again, maybe if it's not the tower, it's going to be the systems and the implementing of the solar panels. And that's going to be the 15 to 20 years after the first term, and it's going to allow the developer to earn back the investment. So that's when the actual energy is also being generated and sold, and it's kind of like the working part of the lease. So again, another reminder, just watch for those automatic extensions, and you may want the ability to negotiate the lease before extending. So instead of maybe looking at the lease and saying, no, I don't want the automatic extension. Well, maybe you do, but you want the ability to actually talk to the company before they automatically extend it. Things like that. So again, just be aware. Rent and royalty clauses. So questions to ask when, or at least be aware of the issues. What are the payments for the easements? Are they going to pay for the easement? Is it going to be one time? Is it going to be upfront, or is it going to be periodic? So over the time of the use of that easement. And then what unit is going to be used to determine that payment? What are your lease payments? Are they going to be per turbine, per acre, per megawatt, or is there going to be this royalty? Definitions are going to matter here, and this is where it can be very technical. So again, if you're looking at one of these, definitely consider working with a legal representative that has experience with these sort of leases. What's going to be included, what's going to be excluded as far as rent or royalty clauses and payments, and then what can be deducted, and then how will accuracy of these payments be verified. So what I'm talking about there and hitting upon is making sure that you're, getting a fair and reasonable payment or rent payment for the area. So how are you going to make sure, how are they going to make sure that everyone is being paid in this fair and reasonable type payment? And it's typically going to be regional, and then depending on where you are amongst the state. So wind turbines, how are these usually paid? So reports indicate that most companies are paying between $4,000 and $6,000 annually per megawatt of tower capacity for a fixed compensation package. For the royalty compensation packages, you're looking at 3% to 5% of the gross revenue that is generated from electricity sales, including renewable certificates. So that's generally what is going on out there. And you're going to also, again, like I said, talk to experts in your area to ensure you're getting what's fair in your market. So it's going to be different in Oklahoma than it's going to be in California, than it's going to be in Maryland. So you're definitely going to want to talk to the regional experts or the state experts and making sure that you're negotiating what's reasonable in your area. When it comes to solar panels, it's going to be a little bit different. These are usually set as a dollar per acre type payment and not in royalties like you see with the turbines. Commonly, the price offered is going to be lower in the development phase, and that's that 3 to 5 year period I talked about when you're talking about the first part of the lease. Then it is going to be in the operating phase of the lease, that 20 to 30 year type area, because that's when the energy is actually going to be generated. That's when money is actually being made. So that makes kind of sense when you're looking at the lease. So if you're confused about that. Let's see, the assignment clause. So the developer can retain the right to assign the lease, to either sublease the lease or convey the agreement to another party. And this may be done with or without your consent, depending on the language in the contract. So there was, I think, a question about what happens if the solar company goes out of business. Well, if they're going to be bought by a larger company, in the lease, they can say what is going to happen if they were to be bought, if they were to go out of business. And if it maybe doesn't say anything about that in the lease agreement, again, talk to your legal representative and consider having something put in there in case that were to happen. Liability and insurance clauses. So provisions requiring both parties to defend and hold the other harmless from claims arising on the various activities of the land is what we're talking about. So a wind turbine collapsed onto a neighboring landowner's property and maybe destroyed a barn, and then the landowner would want to be held blameless in any claim the neighbor would have against the wind company. So this is why requiring insurance coverage levels is a good thing. A lot of you already, if you're operating a farm or a dairy or something along those lines already, you do have most likely an insurance company you're working with. So this is a good time to bring them into the conversation and make sure that if this terrible example happens, that you're covered. Your neighbor maybe can't sue you, And then if they do, that there's some sort of insurance coverage in the case of that happening. And then that's also written into the lease agreement as to who's going to be at fault and also what insurance coverages are going to be required. The tax clause. So this is a question we get quite often. The value of the property may increase due to the facilities being built, and you may want to make sure the lease specifies who's responsible for the increase in those taxes. That's definitely it's going to be a huge impact if you don't look at that issue. It's something we get questions about daily, especially with the ag exempt issue. You're going to want to check with your local assessment office, and at the bottom of the slide here, I have, if you're not familiar with your office already, you can find your office in the state of Maryland, call them up, ask them what the increase of the tax liability is going to be if, for example, you're taking property out of the ag tax exemption into maybe commercial, and they're going to be able to tell you, and then you're going to also want to talk to the energy company and maybe make them responsible for the increase in taxes. Something, again, to look at, talk to your legal representative about, call your local tax assessment office, and get that all sorted out before signing the lease agreement. The future use of the land clause. So what rights will you be allowing the wind or solar company in the way of future development? Would you want to include language in the lease that specifically limits what the developer can do or not? So, for example, you might want to say in the lease such as something like limiting constructing to X number of turbines or X number of solar panels or X number of substations and transmission lines before they go ahead, and you maybe don't limit those things and they have overbuilt maybe more than you had intended them to. So again, something to think about and consider either putting into the lease or talking about up front. The developer may also want to look at limiting the height of structures, and I talked about that a little bit on the previous slides, or the amount of land used that you or your future owners can build upon. They'll want to ensure that the wind patterns or the sun access on the property remain relatively unchanged. And again, that may not only affect you, it may also affect your neighbors, and they're going to have to talk to the neighbors about that. Just remember to keep that in mind. They're going to want to limit to make sure that the most amount of energy can be generated, so whether that's in the wind pattern or the sun exposure, that's going to happen. I see Greta remarked this will involve a major change of zoning on the farm to commercial use. As far as I am aware, yes. Like you're not going to have an agriculture use any longer. Paul, if I'm incorrect on that statement, please tell me. So termination clauses. You're going to want to consider the language that defines when the landowner will have the right to terminate the agreement. Will it be when the rent payments or royalty payments are so many months behind? So this is in case of you're terminating the agreement before the lease is actually up. So if you're not getting your rent payments or your royalty payments, you're going to want to maybe consider putting in, when can I terminate? How long will that be? When would you want the right to terminate the agreement? You'll also want to clarify and define the times when the wind company or the solar company can terminate the agreement. So when do they have the ability to terminate the agreement short of the end of the lease? Both parties want to know what causes the agreement to terminate and don't want to place too much power in one party over another party. So again, even if you're not aware of it, the energy company is going to be aware of it, and you're going to both want to come to some sort of agreement as to when either of you can terminate. Remediation clause. So this is another question we've been getting quite often. So most leases are going to include a remediation clause or require the developer to return the land to its original state. So what the land was before the energy project was actually built. And the issue arises when, well, the lease has gone on for 20 to 50 years. Do we even remember what the land looked like then? So what is basically has been common standard among the us legal people is that consider taking pictures of the property before the project is built, rather than relying on statements of what the land actually looked like. So if you're going to sign that lease and you want to maybe put it in your safety deposit box, take some photos, print them out, and also put that in the safety deposit box. Just an idea, something to consider if you want to ensure that 50 years from now the land is going to go back to what it looked like rather than being torn up or something like that, and maybe it's not as usable as it was before. Federal and state laws. I'm going to go ahead and hand this back over to Paul.
Okay, I'm going to talk a little bit about federal and state laws, and I was going to point out, Lisa brings up a good point on ag excess property, that it will be a violation of your declaration in the state. And eventually I'll get my buttons to work to where I don't have to go down to that arrow every time. So with federal law, we have to start thinking about how will this impact USDA program eligibility for those enrolled in various USDA programs. If you're in the EQIP program and you're going to have to tear up a conservation practice that NRCS has paid money for you to put in, you're going to want to talk with your local Natural Resource Conservation Service office to double check what the penalties are going to be for that, and make sure that whatever the solar company does, they're not destroying any conservation practices that money's been paid for. If you're enrolled in CRP, you're going to want to check with Farm Service Agency to make sure you're still eligible to be in the CRP program with the solar development going on it. You're also going to check with USDA if you're involved in any loan programs. So one of the biggest areas, the other one's going to be zoning, and we'll track back to zoning here in a second, is going to be based on the idea of nuisance, which is in tort law. And the idea behind nuisance is, what is an activity or conduct that's unreasonable and interferes with your neighbor's use and enjoyment of the property? So we all have some use and enjoyment of our property, and when our neighbor's uses start impacting ours, it's potentially going to be a nuisance. There are two types of nuisance. There's private nuisance, where you can only interfere with another's use of their property, or public, where you're interfering with the public's interest in the property or the public's use in the property. And these are typically defined by state law and typically involve health code violations or some sort of larger environmental issue. The reason I say it's a potential issue is a nuisance all depends on where you're exactly standing at that exact moment. If I had been thinking ahead of time, for those that have seen the movie Smokey and the Bandit, I would have put a picture from Smokey and the Bandit in here. But in it, at one line, they talk about just where you're at in the country at that moment defines how dumb you may be. A nuisance is sort of the same idea. Where you're at that exact moment in the country will tell you whether or not it's a nuisance. So if you're in the middle of agriculture, and all of a sudden somebody moves in and wants it to be a suburban backdrop, that potentially may not be a nuisance if they're complaining. It may depend on how much the area has changed over time, but potentially not going to be a nuisance. Now, at the same time, if you're living downtown, somewhere in a large city and want it to be quiet, and all you hear are concerts, people going in and out of restaurants, bars, and whatever nightlife it may be, you may not be able to get the quiet, nice lifestyle you want at night because you're living in a downtown area where that is expected. So nuisance depends a lot on what's expected in the general area. And on health issues related to solar panels, really there have been no cases involving nuisance currently that have involved health issues or anything involving solar panels, so the jury is still out on what is actually going to be a nuisance, at least as it relates to health issues to solar panels. So we're looking at wind farms. What are the potential nuisance claims? Well, there's potentially going to be claims from noise and vibration from the turbines, shadow flicker, ice throws, blade shear, turbine collapse. these are potential areas where we could see some form of nuisance. We have seen very few in the case of wind turbines. Sun, it's potentially going to be, it's reflecting sunlight into neighboring landowners' property. It's a theory that legal commentators have talked about, but we have never seen put into practice. So at this point, it's just a theory that may or may not apply in real life. The other thing is landowners do not have a right to unobstructed views of sunlight from adjoining properties. So what does this mean? Well, if your neighbor decides to construct a barn and it's now blocking the solar panels on the property for commercial that are there for commercial development, the developer may not have a claim against them. So the idea is you don't actually have a right to an unobstructed view of sunlight. So there may not be a claim. This could potentially change if the neighboring land is also leased by the solar company and they're under the same restrictions that you would be as well. And Ashley added this in to help me remember that I'm supposed to talk about zoning moratoriums. And the idea is that, you know, a zoning moratorium is used to suspend the right of property owners to obtain development approvals for a temporary period of time while zoning officials study whatever the particular issue is. There's, as most of us know, these are not limited energy, alternative energy development, and they could be triggered when there's no regulations surrounding something we want to do. And they're potentially only limited to just researching the issue. If I remember right, for those on the shore, currently Talbot has one, a moratorium in place. Frederick has one. And a few other counties around Maryland, I think Hartford and Baltimore County, have been looking at potential moratoriums in place, at least for solar development. And I should point out, if you're in an ag area, is one of the questions I talked about, and I think Ashley answered, check with the zoning officials to see what's going to be allowed in that area for ag. More than likely, if the energy company is talking to you, they have done their background check to know what's going to be allowed and what will not be allowed. They're not going to invest a large amount of money for something that's not going to be zoned properly, so they have probably done their background research. But the way ag is defined across the state in the various zoning codes, it's really hard for us to have a general sense as to what's going to be allowed and what will not be allowed in an area agged for zoned for ag. Sorry about that. So quarter the wrap up. The basic takeaway point in all of this is do your due diligence. When dealing with a company and dealing with a lease, you know, run the company through the Better Business Bureau. Run them through some background checks of your own to make sure they're stable. The question had come up earlier, and I'm trying to go back up and see where it's at. What would happen if the company went out of business? Well, that's a potential issue. So you kind of want to make sure you go off and do a background check on these companies to see what their financial health is. That may not be the, you know, the greatest indicator for a long-term lease as to what their current financial health is, but at least will give you a sense. Many of these companies are just now coming into play. They may not have a long background, but many of them may be a part of larger energy companies that have traditional long histories that we can see that they're going to be in existence for a while. The other thing to point out is when they go out of business, it will depend on how they go out of business and who the potential buyers of that property are. So to answer the last question or the last comment that just popped up, you probably would not own the equipment. The equipment would go to whoever buys the company out in the end, so it may get bought out by another solar company. So you may be dealing with a different solar company down the road than what you're originally dealing with very early on. Have it reviewed by an attorney that's competent in the area. One thing we're working on is we're putting in a grant proposal to try to develop more resources to help landowners understand these alternative energy agreements, and at the same time provide resources to the State Bar Association to train attorneys so they're better handled when you walk in with one of these leases to understand what they need to go through when reviewing them. Like I said, someone sent me late last week a horribly written lease. At least I think it's horribly written for landowners because it protects more the solar company. for the most part, these companies only care about protecting their rights. So you need to at least have a competent attorney on your side who's going to work and negotiate with some of these. And from talking with some of the attorneys, once they know there's legal representation, the companies are usually very willing to help work with that attorney and provide at least additional language to protect the landowner's rights as well. But you need to understand the basics of these things and how they're going to benefit you and how they're going to impact you. They're potentially going to be tying up your land for years, and you need to understand how they're going to operate and have a general sense of that so you know what's expected over this long-term deal. And I thought there was one more question that I saw. How to configure the future cost of energy over the 20-year period will greatly increase, and how to configure your income changes with the rental agreement. And to go to that point, for those in Washington County and in those on the Eastern Shore, so next week, a week from tomorrow on the 17th, we'll be holding a solar workshop at the Washington County Extension Office in Boonesboro. And one of the people that will be there is Sebastian Hody, who is an energy economist here in Ag Econ with Ashley and I, and he's going to talk more about the long-term economic impacts when you're the producer or you're the landowner looking at these things. How do you need to configure what you're doing to this issue? And then Shannon can correct me on the date, but I think it's December 9th on the Eastern at Chesapeake College. We will be doing one, and Dr. Hody will be there as well to sort of talk about those long-term economic impacts as well. Some of the resources we used for this presentation, I think this presentation will be up on the Women in Ag website, and we have the wind leasing page up there. When you look through the wind energy leasing book that they have up there, a lot of the similar issues for solar are going to be present. The royalty stuff's not the same, but the long-term things you need to think about with tying up the land are there as well. So it's a good basic book to start out with, at least for the long-term impacts. To kind of give some plugs for some other stuff, I put some a blog post down there that Ashley and I put together, just some basic background on what you need to think about when you're doing this, but you can find those at aglaw.umd.edu, and you can sign up for updates on the site, and you get those, I think, 2 to 3 times a week, depending on how much we post. And we also put a podcast up there. I started a podcast to kind of talk about these issues, so Ashley and I did a podcast on this as well, and you can find that at that web address there. And I think that is it. So if there are any questions, please let us know.
Thank you for watching our archived presentation of our Wednesday webinar. If you would like to see more archived Wednesday webinars, please visit our YouTube channel, or to find a schedule of upcoming live webinars, visit our website.